Good evening, ladies and gentlemen, and welcome to the 84th meeting of the Standing Committee on Citizenship and Immigration, which I'm happy to call to order today. And we are beginning a new study tonight, studying the federal government policies and guidelines regarding medical inadmissibility of immigrants. It's a new study, and the committee is gathering information from witnesses as we begin this process, and I'm very pleased that we have such a good variety of witnesses tonight coming to help us with this really interesting topic. From the Council of Canadians with Disabilities, John Ray and James Hicks, Canadian Institute for Health Information, Brent Diverty and Chris Kuchek, and Lauren Waldman. Welcome, Mr. Waldman, via video conference. And I think we're going to begin with Mr. Waldman as first witness, just because the technical aspects, things sometimes go wrong, and if we begin with you, then we know we've got your testimony in for sure, but we want you to stay around for questions as well. So we begin with an opening statement from Mr. Waldman.
Thank you very much. So the issue that you're being asked to study is medical inadmissibility. And under the Immigration and Refugee Protection Law, there are two grounds upon which...
If I could just ask you to wait one sec while people put their earphones in, because it's we don't have a lot of volume, and everybody should have an earpiece available. Thanks. Sorry, Lauren.
Okay, it's not a problem. I can see if I can increase the volume, if that would help.
You're good.
Okay. So there are two grounds of inadmissibility under the Immigration and Refugee Protection Act. One is danger to the public, and that is really one that doesn't arise very often. I see cases of people who have tuberculosis. If it's active, they have to get treated before they come to Canada. If it's not active, then they are put under surveillance and they have to follow treatment once they arrive. It's very infrequent that people are refused on grounds of danger to the public. The more common ground is excessive demands on social or medical services. It's interesting to note that the law was changed some years ago, because excessive demands used to apply in all cases involving all applicants for permanent residence, but the Parliament of Canada decided to exempt spouses and dependent children from and protected persons from the excessive demands criteria, a reflection of the fact that the government thought that it was important that those people be allowed to come in and be reunited with their family. So excessive demands now is applied mostly in the case of parents and grandparents, and also in the case of independent or economic migrants who seek to come to Canada. So there are several issues that have arisen in relation to this process. The first is one that was exposed recently by a reporter for one of the news networks, who discovered that the basis for the calculation for excessive demand and the average amount of money, because excessive demand means you cost more than the average amount of money than a regular Canadian, the calculation of how much was average was based upon fictitious information. There was no actual true calculation of the cost of the average person. So that's one issue that needs to be carefully studied by the committee. How do the authorities come to this number that they apply in all of the cases? The reporter discovered that there was absolutely no factual basis for it. But there are other important issues that need to be considered when one considers excessive demands, and they deal with the hardship that is often results from the indiscriminate application of this. For example, one of the most common types of cases I see in my office are people who are trying to bring their parents into the country, and they have medical issues, and they're unable to bring them. And this creates huge problems. It creates emotional issues, because people feel that as children, as their parents get older, they have to care for them. And the application of the excessive demands criteria in this context creates a huge amount of emotional hardship. The second thing we need to consider when we consider excessive demands is the fact that it's also applied in the case of economic immigrants. And one of the things we need to consider is that as the demographics of the world change, and as Canada as a country needing immigrants in order to meet our demographic needs over the next 40 or 50 years, we are competing with other countries who find themselves in the same situation. And Canada needs to understand that by putting up barriers that make it more difficult for the more attractive immigrants to come to the country, this may be have a negative impact on our ability to attract the most qualified immigrants. So from the point of view of an excessive demands analysis, one has to also engage in a cost-benefit analysis. And this requires us to consider the emotional hardship that occurs when people are separated from their family, and also requires us to consider the impact of a strict application of the excessive demands criteria on our ability to attract the most desirable immigrants as we move forward. And so I think that when you consider the medical inadmissibility over the next weeks, you need to consider these issues and consider whether or not, in fact, we need to reconsider the inflexible approach that we've seen applied by the officials to excessive demands over the course of the last many years, and either get rid of the whole notion of medical inadmissibility because from a cost-benefit point of view it doesn't make any sense, or at least guarantee that there's a much more flexible approach that will take into account the hardship that arises as a result of an inflexible approach, and also the fact that we may be harming ourselves by making it more difficult to attract the type of immigrants that we will need in the years ahead. Thank you.
Thank you very much. I think Council of Canadians with Disabilities, are you going to speak, Mr. Ray, first? Thank you.
Me now? Is this on?
Yes.
Yeah, okay. Thank you, Mr. Chairman and members of the committee. We are really pleased to be here tonight and are delighted that you are taking up this important issue. We are here to recommend in the strongest possible terms that the excessive demands clause in the Immigration Act be repealed. And having made that comment, I'm tempted to rest my case right there. But of course I'm not going to. Let's look at it from a number of perspectives. First of all, philosophical. The existing provision, in our mind, is mired in outdated, ableist, offensive, and stereotype notions about disability, where it seems that we are considered automatically to be a burden upon society. Needless to say, as an organization of persons with disabilities, we reject out of hand that notion. However, the continuation of that phrase in the Act is demeaning, and if you think about it from where we sit, basically what that phrase is saying is we aren't wanted in Canada. That's not the Canada that I understand I live in, nor the Canada that I want, nor do I believe the Canada that you and your fellow members want either. So this provision must go. When the Canadian Human Rights Act was proclaimed, we hoped that would signal a new era. It did not. When the Charter of Rights came into force, again we were hopeful, but again disappointed. When Canada signed and later ratified the UN Convention on the Rights of Persons with Disabilities, again we were hopeful because prior to ratification, the Government of Canada consulted its provincial counterparts before doing so. But again, we've seen no movement. Today, we are on the verge of a promised National Accessibility Act. And so we suggest to you that this repeal is long overdue and very timely, either through legislation proposed by you or as part of the National Act, because in order to make the kind of tangible differences in our lives that we want and that you folks have led us to expect, then part of that bill needs to be the amendment of a number of pieces of legislation. In practice, we have an immigration system that runs several different ways. If you're a refugee, the excessive demands clause doesn't apply. If you're rich and have lots of resources, you can argue that you can cover whatever excessive demands costs may exist. And if you are neither, you're often forced to almost beg the minister on compassionate grounds to let you stay in Canada. And it seems that in that case, the squeaky wheel gets the minister's permit. If a person raises enough trouble and threatens to go to court, a lot of times the permit is issued. Well, we don't think Canada should have a several streams kind of a process. We do support the need for refugees to be fast-tracked. We understand where they're coming from. The numbers game. We suspect some people are concerned that if we repeal this offensive section, that Canada will be flooded with applicants for landed status. We see no evidence to support that idea. None. And so we consider this is an outdated provision whose time has come to end. And I want to leave you with one final thought. Consider this list of Canadians, and it's not exhaustive. You will know many of these names. The Honourable Carla Quattrol, the Honourable Kent Hare, Catherine Frazee, the former chairperson of the Ontario Human Rights Commission, Yvonne Peters, who I think is the current chair of the Manitoba Human Rights Commission, Jim Dirksen, formerly with Disabled Peoples International, Sandra Carpenter, leading spokesperson in the independent living movement in Canada and around the world. That's not an exhaustive list by any means, members. Consider this, though. We in Canada have benefited from their work and their expertise, partly because, through good luck, they were born in Canada. What would have been the result had they not been? Because one thing which is common with those peoples and with those individuals and others like Rick Hansen and so forth is that they all have an ongoing permanent disability. If they had lived outside of Canada and had applied for immigration to Canada, how would their applications have been viewed and dealt with by immigration officials? How would they have been? I ask you to ponder that question tonight and as you go forward. And I submit that Canada would not have been able to benefit from at least some, if not all, of the work of those important and significant Canadians, because a lot of them would have been denied the opportunity to come to Canada. That's not the kind of Canada I want. We need to be able to benefit from the interest, the aspirations, and the contributions of everyone. And any notion that disabled people are automatically a burden, we reject, and the work and contributions of those individuals put the big lie to any such contention. I invite you to ponder that point, if none others, and thank you for the opportunity to be here.
Thank you very much. And you asked for a warning, but you were exactly on 7 minutes, just to let you know. Mr. Diverty? Diverty or Diverty?
Diverty.
Diverty.
So, good evening, Mr. Chair and committee members. On behalf of the Canadian Institute for Health Information, I'd like to thank you for the opportunity to appear before the Standing Committee on Citizenship and Immigration. Since 1994, CIHI, the Canadian Institute for Health Information, has been an important organization in Canada's health sector. We are a not-for-profit, independent body funded by the federal government and all provinces and territories. Our board of directors is made up of deputy ministers of health and other health system leaders representing all regions of the country and the federal government. When we were created over 2 decades ago, we had 3 databases. Today we have 28 and data sharing agreements with every province and territory, Health Canada, Statistics Canada, and the Public Health Agency. CIHI is a leader in health data, methodologies, and system performance measurement, and we are recognized internationally for our work. Over 20 years, we have become the authoritative source on a range of health system topics, including health expenditures. Our role in the health system is to make data publicly available for people like yourselves, Canada's policymakers, as well as the health system, researchers, and the general public. We are neutral and objective in fulfilling our mandate to deliver comparable and actionable information. Our aim is to give people the tools they need to drive improvements in healthcare, health system performance, and population health. Ultimately, we work to improve the healthcare system and the health of Canadians across the country. Earlier this month, we released our annual report on health spending in Canada. National Health Expenditure Trends examines how much is spent on healthcare each year, where the money comes from, and how the money is spent. For the past 20 years, we've been responsible for reporting on health spending in Canada, continuing work that began 40 years ago with the purpose of supporting the development and evaluation of health programs in Canada. Our report is based on a classification system that is consistent with international standards developed by the OECD for reporting health expenditures. So the focus of our work is on health system expenditures. Total health spending in Canada includes both public and private sector expenditures. These are further broken down into broad categories such as hospitals, drugs, physicians, other institutions such as long-term care, nursing homes, and professional services for things like dental and vision care, etc. As we call it NHEX, and this report combines readily available information from public accounts, annual reports, main estimates, Statistics Canada, and private health insurance. And this information is used to produce estimates for the current year. Current year estimates are revised to actual expenditures once they are confirmed, typically with a 1 to 2 year lag. And it's just one example of how publicly available data is used by government officials, provinces and territories, other third-party organizations, all with the common goal of improving the health of Canadians. So Canada's health spending is forecast to grow almost 4% this year to $242 billion. And this is a slight increase in the rate of health spending growth. We've seen an average growth rate of about 3% since 2010. Health spending is forecast to be $6,604 per Canadian. This is almost $200 more than last year. Total health expenditure per person is expected to vary across the country from $7,378 in Newfoundland, Labrador, and $7,329 in Alberta to $6,367 in Ontario and $6,321 in British Columbia. This variation across the country is for many reasons, including differences in population demographics and health status, prescribing practices, public program design, and other factors. The results of this report are also used to compare Canada to other OECD countries. And in 2015, which is the latest year we have actual expenditure data for, Canada's per-person spending was among the highest internationally at $5,782 Canadian dollars, a figure comparable to the Netherlands, France, and Australia, but much lower than the US at $11,916. Hospitals, drugs, and physician services are the categories that continue to use the largest share of health dollars. Over time, the share allocated to hospitals has been decreasing, and the share allocated to drug spending has increased. In 2017, drug spending is expected to grow at an estimated 5%, spending on hospitals about 3%, physician spending growth about 4%. We've identified several major cost drivers that include inflation, population growth, and the aging population. Population growth and aging account for 2% of total health spending growth per year. Over the last several years, we found that population aging in particular is a modest but steady cost driver, about 1% per year. In closing, I'd also note that we have a new strategic plan for the years 2016 to 21, identifying strategic goals that build on our core strengths as an organization and focus on priority populations, including seniors, children and youth, Indigenous, and those living with mental illness and addictions. These priority populations were identified with our stakeholders, including the federal government and the provinces and territories. I thank you for the opportunity to present this information. My colleague Chris Kuchek and I would be pleased to answer any questions you may have.
Very good. Thank you very much. We're going to begin with Mr. Tabera for a 7-minute round of questioning.
Thank you, Mr. Chair, and thank you for all the witnesses for being here today. I asked this question previously in another meeting, and I want to revisit it again. I understand that if one member of a migrant family is considered medically inadmissible, the whole application is denied, even if the rest of the family does not have any pressing health concerns. And we've seen examples of this previously. I think the first question will go to Mr. Waldman. Sorry, if you can give us some suggestions on, and maybe, for example, if you've had any cases that have been denied and rejected upon the whole family when one individual was looked at as medical inadmissible.
Yeah, under the current Immigration and Refugee Protection Act, if a person, one of the members of the family is inadmissible, then the entire family is inadmissible. And this happens all the time. So if the most frequent scenario is we see someone who's sponsoring their parents and a younger brother. The younger brother might have some medical issues. As a result, neither the parents or the younger brother can come. And that often creates a lot of hardship. And there doesn't seem to be any rationale behind it. And I think it would be one way the committee could at least look at a compromise in those types of situations. I agree with the person who spoke from the Canadian Association of Disabilities. I think that you have to look deeply at all of the medical and disability issues. But when you're focusing on this particular question, there's not a lot of common sense behind not allowing parents to come if the child is inadmissible. But that happens all the time.
So if we're looking at migrants coming in, economic migrants to fill a certain sector in our region, that's, for example, if we're looking for engineers, if we're looking for doctors, an example in Waterloo region in the high-tech sector, and we find really great candidates from around the world that have exceptional skills and qualifications. These are the type of individuals that we want to attract. And you mentioned in your statement that there's not a measure of an economic benefit. Is there something that the government can look at through an economic benefit, looking at individuals that have these qualities and skills that we need here in Canada, and to look at how we can look past an individual that has medical inadmissibility if it's just an individual in the family?
Yeah, that's what I was trying to say. A lot of times what we see is that we find highly skilled people who are going to make an important contribution, but yet because one of the members of their family is medically inadmissible, they're not allowed to come into the country at all. And we're competing with a lot of other countries for the same skilled workers. And if we put up these impediments, we're going to lose the battle of attracting the best. So there's no flexibility in the system now, and so if one of the children is inadmissible, the immigrant's application is refused, and this creates a serious problem. So I think we need to look at this whole question and look at finding ways to be more flexible in the application of medical inadmissibility.
If I can get Mr. Diverty to expand on that as well.
Actually, I think it's important for me to state that our organization takes no positions on policy, and we're here and happy to speak to the data and the information that we produce. So really our remit around this issue is around the health expenditure numbers and report that I mentioned in my opening statement.
Okay. Maybe if I can get from Mr. Ray.
Well, some of the cases that come to us involve families where the son or daughter has a disability and that person is deemed inaccessible. Is deemed ineligible. And so the family has the heartbreaking decision to make. Do they come to Canada and leave their son or daughter behind, or do they not come when they want to try and make a new life for themselves? So despite what may be in the legislation, the way in which it applies seems to be quite different to us. And that, of course, is why we are recommending strongly that the whole notion of excessive demands be repealed altogether.
So we want to take in suggestions from all the witnesses that are here today. So if you can give suggestions for the government that will help get the balance right in protecting publicly funded health and social services and welcoming new members into Canadian society. I'm just wondering if we can strike a balance. And if you look like you want to comment on that, Mr. Ray.
I do. When you think about some of the other groups that are allowed in, people who are heavy smokers, people who are at risk because of potential accident, whatever, those people are allowed in. They may be non-disabled now. We sometimes use the term TAB, temporarily able-bodied. But there's no guarantee that tomorrow those persons won't suffer an accident or sometime shortly down the road develop an illness because of their lifestyle. Yet questions about supposed excessive demands did not appear to be asked of them. So again, that's why we consider this provision so inequitable and needing to be repealed.
30 seconds.
That's fine.
You're okay?
Yeah.
I'm going to take your 30 seconds then. And I just want to ask the folks from Kai about that averaging function and how is it actually done? Is it just total cost divided by population?
Yes, that's absolutely correct.
So it's not, there's no statistical analysis in that in terms of regression, any kinds of looking at a sophisticated system. It's simply aggregate amount divided by the number of people.
So starting from that 242 billion number that I quoted to get to the roughly 6,600 per person, yes, there is some estimation within the methodology for some small parts of the overall cost, but most of them are coming straight out of provincial budgets.
Okay, thank you. Mr. McGuire.
Thank you, Mr. Chair, and I want to thank the witnesses for their excellent presentations this evening. Just several questions in maybe a short amount of time, but I wanted to ask Mr. Ray, if I could, just exactly, well, of the numbers, can you give me an example? I've heard of as many as 900 that applicants a year that are declared inadmissible. Do you have a number more accurate, or?
I'm afraid I don't. We've heard those numbers as well. It sounds like a lot to us, but we've heard those numbers.
And the number that I've had was 900, and that it's 0.2% of the persons that are brought into the country. Excuse me. And so that seems like a rather small amount. I want to go back to your comment, and I believe it was Mr. Wallner's comment. If you could expand on that, Mr. Wallner. You both had, I thought, a solution to this, and I wonder if you would put it on the record again.
Do you want me to go?
Yes, please, Mr. Wallner, first.
I think the fact that you pointed out that it's such a small number, you have the cost of processing all of these applications. Each person has to go through a medical check. They're then reviewed by medical officers. I mean, the cost per application of the medical process is very high. To screen out effectively 900 applicants, one wonders from a cost-benefit point of view whether it makes any sense to do that. In any event, the argument that I made was that we should probably just eliminate medical inadmissibility because the number is so small, the costs associated with it are very high. And in addition, it impedes our ability to compete for the immigrants that we need. And finally, it creates a lot of hardship.
Mr. Ray, could you add to that?
We agree. The numbers and then the numbers you quoted, sir, bear out my earlier comment that Canada is not likely to be flooded with a huge number of additional applicants should this discriminatory provision be repealed.
Thank you. What types of disabilities are the main ones that people are repealed for? Are they physical or mental, or where are we at? And is there a divide in that, or is there
I don't think I have a breakdown for you, but a lot of the cases that I know that have come through our doors, through our national office, seem to be on the ground of intellectual disability.
I agree. I think we see in our office people with medical issues, heart attacks. That's part of it, but many of the cases also are people who are supposedly mentally disabled in some form or another.
Thank you. To Mr. Everty as well. I noted in your presentation that basically, healthcare is going up 3% for hospitals, 5% for drug spending, 4% for physicians in 2017. I don't doubt that, but it also says that 2% of the health spending per year comes from normal population growth and aging. And there's not much we can do about that, I suppose. It's quite a good thing that our population is growing. But I wanted to know then if that certainly narrows down the overall cost of real increases in a particular item. Can you elaborate on that, or is there any is there?
Well, I think that obviously there's there's both the additional services that are provided, and then there's the price of those services, and it really starts with that. And as you see more people, you have more services, there's more costs, and also on the price side. And we're seeing sort of, I think, modest growth on both of those. We've got an aging population demanding more services. We have more people of all ages with more services, and we do obviously see wage and price inflation in there as well, and that's really added up to over the last several, I'd say 4 or 5 years, about a 3% average increase in spending. It was a bit lower a few years before that. We basically see health spending sort of move in lockstep with the economy typically when you look at the last 20, 30 years. So when the economy is going well, you see more health expenditure, and it slows down in times when the economy is not going so well.
Thank you. Mr. Wallner, you said that there was a danger to the public. There's two reasons: the danger to the public and the excessive demands on services are the reasons why inadmissibility. The danger to the public, is that a small portion of the overall, or the excessive demands on services is the major one?
Yeah,
is that correct?
Think, yes, I think that's right. And from my experience, it's a very small percentage. People who get medical exams, sometimes they have conditions, they're required to have them treated, and then once they're treated and they're cleared, they come to Canada.
So we've seen that there are huge costs. They're growing, but they're not growing perhaps as much as the overall when we look at taking into the physicians' drug spending and that sort of thing as a basis, or the 2%, pardon me, as the health spending per year on aging. Can you? What would be a fair compromise or a fair solution? Canada's a pretty fair and generous country, as we've all known, in these areas. And is there a limit? How would we deal with this? And given that there's huge costs already for these 900 persons, some suggestion here that it may be a saving from not having to put them through all the paperwork we put them through. But what would be a reasonable process here? Is there a compromise with the provinces in regards to this, so that the provinces can actually have if they decide that they want to fund a particular case, that they can go ahead and do that?
That used to be the way it was done. For example, Manitoba had a scheme where they could, you could pay amount of money as a bond for future expenditures, and that was canceled. So there are ways that one could move forward and look for compromises in terms of like people offering to pay bonds, or provinces agreeing to allow people to come into Canada. Obviously, this is a shared responsibility. Both immigration is, so that any decisions you make are going to have to discuss with the provinces as well, especially given that the medical expenditures are provincial. But I think that when you look overall at the number of people that we're talking about, 900, even when some of them have significant costs, as a factor of the total amount of money you're spending, it's insignificant in terms of healthcare dollars, and it creates a whole series of impediments to both family reunification and also to having the best and most skilled people come into Canada. So when we look at all of these things, I wonder whether it makes sense to continue with this program.
Thank you, Mr. Waldman.
Can I just add that if that were to occur, that could set up a patchwork of eligibility province to province, and I don't think that's something we want in Canada.
Thank you, Mr. Ray. Ms. Kwan.
Thank you very much, Mr. Chair, and thank you to all the witnesses for your comments. I certainly appreciate and agree with the suggestion that we should actually get rid of this criteria altogether. I think that if you look at it, it is an issue around really picking and choosing and saying to the world that people who have different abilities are not welcome in Canada, because that's at the end of the day what we're talking about. But to that end, so the idea of, just sort of build on this notion, the idea of somehow fixing the issue somehow, somewhat, with a patchwork approach. So, Mr. Ray, you've expressed very clearly to say that that would not work, and Mr. Waldman, I think we've heard from you as well to say that given the context of the small number of people that would fit into that category is not perhaps the right approach to go. Now, I just want to touch on this issue too. We had officials who came forward and advised this committee that, in fact, they don't evaluate the contributions of individuals and their family units. You could be a family unit with somebody who has, quote unquote, someone deemed to have excessive demand, or even the individual with the different ability, that they don't evaluate those contributions of those individuals. They only look at strictly on the cost side. So I wonder, Mr. Waldman, if you could comment on the problem with that kind of evaluation, and not to mention in your statement as well in the opening that, in fact, through various media reports, that it's been found that IRCC's approach to assessing the cost is fraught with problems.
Well, I think the point is well taken in the sense that if we're trying to compete for the most skilled workers, if we make it difficult for them to come in by saying, well, you can't come because someone in your family has some kind of disability, we're not going to be able to get the workers that we require. So an approach that only looks at the medical cost and doesn't look at the human capital that that person is bringing into Canada is one that's fundamentally flawed, and I think it's harmful overall to our ability to attract the most skilled immigrants over the long term.
Thank you very much. Mr. Ray, do you have anything else to add?
Agree totally with you. This seems to me like a very arbitrary process, that when a particular disability is identified, then chances are that person is automatically excluded. Well, that does not take into account the fact that telling you that a person has a given disability, I think, tells you a lot less than many people think it does, because it doesn't tell you the particular degree of that disability, nor a person's background, attributes, and how they deal with the realities of their particular disability, nor does it speak to the contributions that person might make if they come to Canada. And I think those are contributions our society wants and needs.
Mr. Waldman, I'm wondering if you have come across cases whereby someone was denied based on this excessive demand provision by just a small amount of dollars. And given the fact that we now know that how the government came up with the figure to determine what is deemed to be the appropriate measure is flawed, I wonder if you can share with us your experiences on how often does this happen where people are denied because of a fraction of the dollars to which they exceeded the amount that was deemed to be the average cost, and given that that's the reality, what should the government do about those kinds of cases, if anything?
Well, I think probably it's too late to really deal with past cases. I mean, they've been refused based upon data that we think is inaccurate. I mean, we see it in two ways. First of all, the government has to estimate what they think the likely cost will be for the individual who's applying to come to Canada. And so that's based upon arbitrary assessments of services that the government believes that they might need. I mean, I'll give you an example. We have people who have some kind of mental handicap, and the government says they're going to need special education, and they factor that into the cost. And special education is quite expensive for sure. But what we see, for example, is people who come at a certain age don't speak English and are not likely to be able to speak English, and the special education programs aren't offered in the language in which they speak, and yet they're being costed as if these programs exist when in fact they don't really exist. So that's the kind of arbitrariness we see in the system as it now develops. And when you couple that with the fact that the number that the government has been using for the average cost, because remember, the average cost isn't the average cost of a Canadian, it's an average cost of a person of the same age group. So as you get older, the cost goes up and the average goes up, but the government's estimates have been off. So those two things, when you put them together, there's a lot of people who are being rejected unfairly. If they've been rejected unfairly in the past, there's not much we can do about that. But we have to make sure that if this program continues, that it's, which I hope it doesn't, but if it does, that it's based upon fair and accurate data.
On a similar track, we've been talking about people with various different abilities. There's also another issue related to this, and that is for people who have HIV and AIDS. For example, that would also be deemed under this provision to be an excessive demand. And I wonder, Mr. Wallman, if you have some comments about that.
Well, it's been an interesting question because as the treatments for HIV have gone up, it's certainly not a problem that creates any kind of public danger. But we do see people refuse because of the cost of the medication is quite high. And so people are being refused because the government estimates the cost of the drug cocktails that they're going to need and says it's above the average. And so this creates a serious problem. And I've seen quite a few cases where people were rejected on that basis.
So then to fairly apply a policy in this area, really what I'm hearing from the both of you, and I'm sorry to our folks from CIHI, it's not I'm trying to exclude you, but because you can't really comment on policy, then really to make sure that we have a fair system, right? Then the thing that the government really needs to do is to get rid of this provision. That's what I'm hearing from both Mr. Ray and Mr. Wallman.
If you look at the history of Canada's immigration system, in the past, other groups were arbitrarily excluded, and Canada has changed sometimes more slowly than various groups would have liked. And so now we just think it's time that Canada continue that incremental improvement in its system by removing this. We think it's our turn to be more fairly dealt with than is currently the case.
Thank you, Mr. Ray. Mr. Sarai.
I want to thank you all. I think it's pretty abundantly clear that most of us here are very sympathetic to this and think it's timely for change, change in the right course. My own calculations, it appears that 44% of immigrants are exempt from this, and about 56% of immigrants are the ones that have this legislation apply to them, the economic and the parents and grandparents. I wanted to ask CIHI if you could, you provided data used to calculate the average Canadian's health needs. Do you believe this data is the most appropriate metric to decide whether a potential immigrant will introduce excessive demand to the health service?
I think what we provide is the estimated and actual cost of health care for Canadians. And I think that, what we hope and aim to do with that is to make that available so that it can be used for policy making, for system performance, et cetera. But I think at the end of the day, it's really important to say these are simply budget estimated numbers, like for the current year, that come out of provincial budgets, some other data sources that we use, and we create an estimate of the expenditure for the country, divide by the population and get a number. We can also do that by age groupings, and we can do that for each province and territory. So you get a range of estimated average costs for different aspects, as I mentioned. But really, that's where I think, job stops, and that's where we make those available for policy and system performance.
Sure. Now, you say the average cost is about, it ranges of province to province, but say 7,000 is just an arbitrary, an easy number I'm using. If you did 900 that were refused, that's approximately 6.3 million would be the average cost of a person, but what would you consider the average cost of somebody that is currently refused or considered inadmissible? Is there an average number that you guys have been able to calculate on that?
The way the data comes to us, it's often in aggregated amounts, and we're not able to disaggregate it by things really other than age groupings and provinces.
If you took all the immigrants that are coming in and you allowed the 900 that are currently considered inadmissible, and you put the amount of cost that they had versus the average cost of the others, would it not be the same average as we currently deem? Wouldn't it average out? Because obviously in the Canadian population, we have people with excessive demand, and so is the public that is coming in. Would the average not be 6,300 or in British Columbia, or 7,000 on average? Would it not come out to the same average?
It's a good point that you make. I think we're saying we're going to spend roughly $242 billion on health system expenditures this year, divided by our population. That's the average. There are a range of people within in that number that use different health care, and we know, for example, if you're below 1, it's about $10,000 a year. If you're above 80, it's over $20,000 a year, and there are amounts in between. So I think that there's nobody being excluded from that number. That's based on the numbers that we're getting from provincial budgets.
Would it be possible for you to calculate the cost of the, say, potentially 900 that are considered in the excessive demand, if you looked at the Canadian population, to see what that cost is? I'm not saying that this is a cost issue, but obviously anyone who's going to approve this is going to look at a number to see what it would cost, and 6.3 million would be what it would cost anyways if they're a healthy individual by their normal demographics. So what I want to know is would it cost 15 million for them? Would it cost only 14 million? Because then the Canadian public and our government could know it's only another 3 million or another 5 million or 10 million or whatever the cost would be. Would that be something you could actually, out of the data you have based on even Canadian that are considered in the excessive demand category, what an average cost would be for 900 people?
Unfortunately, in the way the data come to us, we're not able to disaggregate it in the ways that you describe. But what we are happy to do is to make available any of the data that we have on this issue. So if someone wanted to do some modeling work around that could be done. It would largely be based on the data that we've provided here, which really, as I said, it really disaggregates by age groupings, by provinces, et cetera.
But if we took an average aggregate of the average population that comes in, the number would come out to the same as what Canada has. So if we did not exclude the 900, we took 300,000 immigrants, of which 0.2% were considered excessive demand in our numbers. The average cost would still potentially be the same as the average Canadian cost. So on average, they would not be a burden.
It based strictly on averages. It's hard to imagine how 900 people in 35 million could affect our average health care per capita of $6,600.
Thank you. Mr. Waldman, I'd like to ask you, in your experience, how likely is it that, immigrants denied PR status due to alleged medical inadmissibility are allowed to provide a letter explaining how they would mitigate the costs, which would otherwise fall to our health system? In your experience, how likely is that such a letter or such mitigation factors actually deemed admissible? So how many are successful based on their application?
So it's important to know that only applies to the social services aspect, not to the medical aspect. So if a person's found inadmissible because they're going to cost a lot of money to social services, special education, those or respite care, those types of services, then they can produce a letter explaining how their family's going to help, or they're going to hire private individuals. My experience is that in most cases they're not successful because the health authorities are very reluctant to accept these types of undertaking. Having said that, I have been successful in a few cases, but the vast majority of the cases where the fairness letters are provided, they're not accepted.
You also said it makes no difference from a cost benefit perspective. Can you just quickly elaborate on that?
Yeah, what I'm saying is that given the overall cost of the healthcare, and when you're talking about 900 people, which is such a small number of people, even if those people exceed the average cost by double or even triple, when you consider that as so as you said, if you multiplied 900 by 7,000, that's 6.3 million. Even if we said, well, these people on average, these 900 are going to cost triple, you're looking at maybe 12 million extra dollars. And it's really not worth it.
I need to end you there. Ms. Rempel and Mr. McGuire for 5 minutes.
Thank you, Mr. Chair. I'll be brief. I would like to give verbal notice of the following motion, that the committee invite the Auditor General to appear in a televised meeting with respect to Report 3 of his fall 2017 reports dealing with settlement services for Syrian refugees, excuse me, and that officials from IRCC also be asked to appear at the same meeting no later than December 7th, 2017. Thank you. I'll pass the microphone over to Mr. McGuire.
Thank you. That's now been received.
Thank you, Mr. Chair. I want to just carry on with where Mr. Sarai went with the whole process and your last comments, Mr. Wallner. I just put down from the numbers that you gave us, Mr. Deverty, was it over 80? It's a cost of $20,000 in the healthcare system for a senior? Over 80.
It's around $20,000.
Around 20. Okay. I look at 900 seniors then as an $18 million cost, and you just indicated, Mr. Wallner, that if we tripled this, it would be somewhere in excess of 12 million more. I did the numbers that, according to the CIHI number here of $5,782 for a average person spending in Canada on healthcare at 5.2 million, triple it is 15.6. I guess I look at your situation and, whether or not it's 900 is the exact number of people that would be impacted by this, or 1,900. Is there, do either of you, Mr. Wallner or Mr. Ray, have any idea of what those costs were in regards to administration, or would you have those, Mr. Deverty from CIHI, on a number for the costs of the admissibility for doing paperwork and that sort of thing for each individual? Or is there an average, as you've given us for healthcare costs, is there an average for paperwork just for healthcare in Canada as well that would apply here?
No, I don't have any such number to give. I mean, we track administration costs for healthcare overall. They're roughly about 2%, but that's largely ministries of health. Doesn't include the administrative costs of organizations, but I don't have a number specifically for what you're looking for. Okay.
Yeah, I think that someone mentioned earlier too the costs of family reunification and the costs of the family impacts. I've got situations that happen to come, Mr. Wallner, from Manitoba myself. You mentioned it earlier. There's a situation of human capital involved here, where the families can't get on with their regular life because they're so busy worried about the person in the family that's got this disability, and they need to be able to deal with that locally and in their own family. In this case, the person was trained in a particular occupation that was deemed to be a fairly high-paying occupation, I would say, and they're working in one here in Canada now at a much lower return because they have been held up for like 6 years to get, some years to get the, become permanent residents of Canada. They can't even go and train to get the upgrading that they need to go back to their previous profession. This is a detriment to the community they live in because there is a very big need for the person's skills in that area. The town has come together fully to adopt and accept this young person into the school system, into the community, and yet there's still a situation here, a few years later, that we're still dealing with this. And so I wonder if you can make any kind of comment on that whole human capital part of it.
Well, I think what we're seeing, and your case shows this, is there's a lot of situations where people who have a huge amount to contribute to Canada are not able to do that because they have to spend, either they can't come because of the medical issues, or they have to spend so much of their time worrying about dealing with the problems of the people that aren't able to come, that they're not able to make the contributions. So when you factor that in and you add to that the limited amount of money we're going to save, I think that we have to really seriously rethink this whole process. And in terms of the costing, I think if you ask the officials at immigration, they do have to do a costing in terms of the application process. So I would expect that they probably could provide you with a figure as to how much it costs for the medical processing.
Thank you. Mr. Ray?
You have 10 seconds.
Oh.
You can do it.
You raise an interesting example, and I wish we could get back to discussions about the humanity here rather than just the overall cost. I think settlement organizations can help us a lot. I think your example shows how community creativity can help mitigate some of the perceived costs and can help individuals settle in our country.
Thank you, Mr. Ray. We have time for 2 minutes from Mr. Oliver. Erskine Smith.
So thanks very much. Mr. Waldman, you'd made the fairness point about hardship, and Mr. Ray, you reiterated that just now, that it's dehumanizing in many ways to reduce a person to a number. But Mr. Waldman, you also made the point that we are losing as a society otherwise contributing new members of our society by virtue of this analysis. And to just a clarification point, so when the excessive demand consideration is made, that's just in relation to the individual, and it's not a holistic consideration of the family as a whole and the contributions that other families would make. That's correct, right?
Yeah, that's right. So that's the problem.
And second, in your experience, of the 900 applicants we've heard, which is a tiny fraction of the total immigration number, but the applicants you deal with specifically and have dealt with in the course of your career, how often is it just a single individual coming where there isn't a contributing member in the same way or to the same degree in the excessive demand rejections?
Well, there's two, as I point out, there's two categories. One are the family, the parents and grandparents. So usually you've got the parents, and there might be one parent who's inadmissible, the other is not. But in the economic category, it's often you've got several people are contributing and maybe one child who has an issue, and that can be the impediment. And those are the cases that are really problematic from a practical point of view. Now, I want to clarify that I agree with Mr. Ray in terms of the moral issues involved, but I'm trying to appeal to your practical notion of what makes sense economically as well.
I think for making the case, the fairness point is important, and then the economic considerations would underlie and support it, hopefully. And the last question I would just have, because I know you publish in this area, other jurisdictions, they face similar questions. Do they have similar answers, or have they moved away from categorizations like excessive demand?
I think it depends on the country. I think a lot of countries are proving to be much more flexible, and Canada has to start worrying about the fact that we're competing.
Examples?
Lose good influence.
Do you have examples of model countries in this regard?
I'll send you them.
Okay, thanks very much.
Thank you very much. Thank you to our witnesses. That ends our first panel. You've set the bar high for the next panel. We thank you for your time, and we're going to take 2 minutes to change our witness name tags. We're going to reconvene now. If I could have everyone take their seats.
It feels like Christmas or something. Everyone's so happy to be back.
I know you're happy to be here, so we're going to begin. If I could have the members take their seats. And we're going to, we have three witnesses, well, there are more people, but three 7-minute blocks. And we're going to begin with Michael Battista and Adrian Smith. And I believe Mr. Battista is going to begin.
Yes, thank you very much. We're very pleased to be here, and we're very pleased that the committee is looking into this very important issue.
Could I have attention, please? I would just like members to please take their seats. Thank you.
As I was saying, we're pleased to... All right. Thanks. All right. Thank you, Mr. Chair. My name is Michael Battista, and I'm joined by my colleague Adrian Smith from Jordan Battista LLP. And we really consider ourselves among the bar as being sort of medical inadmissibility specialists. We do a lot of this work. Our expertise really started in dealing with cases of applicants with HIV, but really it's now expanded to cover broad range of health and social services. I would say probably medical inadmissibility files are about 20% of what our office does. And I wanted to start off just by talking about wait lists for a moment. So I think wait lists are a little bit of a red herring. We have seen hundreds of procedural fairness letters in our office, and I can't think of one letter that has relied on wait lists or increase in wait lists to justify a refusal on medical inadmissibility grounds. So I think part of this is the problem that the government has in kind of justifying or pointing to an applicant who would significantly increase a wait list such to increase morbidity or mortality of Canadians. Our main point is that 38(1)(c) is not sound public policy, and this is aside from the constitutional issues, this is aside from the anguish that it causes to people. And I want to reiterate what Mr. Waldman was referring to before. I think if we just look at cost alone, I think it's very questionable that this provision actually saves money. And if we look at fixing the provision, I think the provision will be very, very expensive to fix. So let's first of all look at the unlikely cost savings. So let's take the high water mark of $27 million. That's what the government witnesses were using to say the savings was. We have really strong concerns about this figure. We think it is artificially high, but let's just, for the sake of argument, take the $27 million figure. We urge the committee to look at the costs of enforcing and administering this provision and to take that into account to see whether there is, in fact, a net savings in administering and enforcing this provision. This provision really deals with layers and layers of government administration and decision making. And I'm just going to give you some costs that you might want to consider. So the costs of panel physicians worldwide who are the first assessors of this information. There's usually a back and forth between family doctors and panel physicians. There's regional medical offices. There's the Central Medical Admissibility Unit here in Ottawa that's responsible for preparing the procedural fairness letters, researching costs. There's visa officers who have to deal with whether to uphold the findings of the Central Medical Inadmissibility Unit. These visa officers not only make those decisions, they often have to deal with requests for waivers on humanitarian and compassionate grounds. They deal with requests for temporary resident permits. So all of those costs have to be factored in. And then, of course, in our office, on a regular basis, we challenge these findings. So there's also the costs of proceedings before the Immigration Appeal Division. There's costs of federal court. You know, when you're in litigation, costs rise dramatically. So I urge the committee to consider all of these costs and weigh them against that $27 million figure and really determine whether, in fact, this figure is saving public resources. Our feeling, our gut instinct is that actually there's probably very little savings here, and in fact, there's probably a net cost in terms of public resources. I'm just going to touch on the mitigation plan. So these mitigation plans are things that applicants do. They frequently pay us to construct these mitigation plans for them, and they're really designed to ensure that the government knows that a particular applicant won't access the services that are feared to present an excessive demand. The problem with these mitigation plans is that they basically disappear. They evaporate after a permanent resident becomes a permanent resident. So there's no enforcement at all of these mitigation plans, even though they're relied on heavily to approve permanent residence for an applicant. So it's entirely possible that a person who's been approved on the basis of a mitigation plan for whatever reason, for a change of circumstances, for whatever reason, actually accesses those resources that the government has assumed they wouldn't resource. And there's very little recourse from this. We are not advocating that an enforcement scheme put into place to enforce these mitigation plans, because I think that that would just cost more and more public resources. I think anytime you set up an enforcement scheme, you're just sinking public dollars into a system. So overall, I think that that it's very questionable whether this provision saves the government any money. I think it's probably more possible that it's costing the government money, and the mitigation plans are very ineffective in assuring the government that excessive demands are not accessed. I'm going to turn it over to Ms. Smith to talk about procedural fairness letters.
So like Michael said, our firm really does specialize in representing people who deal with medical and disability issues. So I do want to focus on two examples from our practice where we've seen these real problems with procedural fairness letters. So one of the first problems that I see is the fact that this excessive demand threshold, which is currently set at $6,655 a year, it's not accurate. We saw that this Global News investigation from July 2017 found that the IRCC isn't even considering this social service costs. They're costing it at $356 per Canadian per year. Included in that number isn't special education services, which we know is 1/3 of the people that we're talking about under medical and admissibility. So I think there's a real problem with the number. And like Michael said, the amount of resources that the IRCC would have to pour into making this number accurate is going to be significant. So we're coming to the situation now where is this a system that's even worth saving? So this number of $6,655 per year is really so important. It means everything to the client. If you're $1 over this number, then that makes you inadmissible to Canada. So we had a case recently in our office where the IRCC said that the cost of our client's HIV medication was $400 over the excessive demand threshold. Now, our client had an advanced degree. He had years of management experience at an international accounting firm. There was no opportunity to take into account the fact that he's going to contribute significantly to the Canadian tax base. Now, I think the interesting thing is that, his desirability as an immigrant to Canada was really reduced to this $400 over the $6,655 per year. Now, the second example that I want to give from our practice deals with the kind of discriminatory nature of this section of the law. The IRCC has repeatedly stated that medical inadmissibility is tied to the cost of services and not to the health condition. But the issue is really if every single child with a disability is actually getting one of these procedural fairness letters, then in fact it is de facto discriminatory. So we're questioning the implementation of this law, and we're urging the committee to repeal it. You'll hear from other witnesses. We've heard from the panel before us. This is a system that discriminates against persons with disabilities. In 2015, we represented the mother of a 14-year-old teenager named Jasmine. She was found inadmissible because she was deaf. Her case was heavily publicized in the media. And the procedural fairness letter that Jasmine's mother received essentially said that her daughter would be a burden on Canada. Now, I think the sad part about this is that Jasmine's disability really is just one part of her identity. But the IRCC really saw this as the only relevant part of her identity. So I think it is discriminatory to see persons with disabilities as a burden. If you speak to any parent who has a child with a disability, you can see the positive kind of change and impact they have on their family, they have on their community. Jasmine's mother worked for 7 years within Canada. She paid taxes every single year. I met Jasmine last year in Vancouver, and she's thriving in her school. She has so many friends. It's one of those situations where she really isn't a burden on the social system. She's attending a public school in BC. And I think it's one of those processes where Jasmine and her mother should never have been subjected to this discriminatory process.
I'm going to need to get you to wrap it up.
Yeah. So that's actually where I'm going next. So because of these two examples from our practice, we really have to come to the question of, is there a solution, or is this a section that should be repealed? And we are recommending that the section be repealed because we feel that fixing the issues with the procedural fairness letters, it is going to require, like Michael said, significant government resources. And if the purpose is actually to save the government money, it doesn't make more sense to put money into a system that is broken. And we strongly feel that this is a system that's broken and it's not worth fixing. Thank you. I look forward to your questions.
Thank you. Mr. Tomlinson and Ms. Johnson.
Good evening, committee. I'm a Jamaican lawyer working with the Canadian HIV/AIDS Legal Network, where I collaborate with local groups to challenge HIV in the Caribbean. Now, as a Caribbean immigrant to Canada, I'm aware of our shared history of discriminatory colonial-era laws. Canada has excluded immigrants with disabilities since before Confederation, when it denied immigration to persons considered physically and mentally defective. While the Immigration and Refugee Protection Act no longer employs such reprehensible language, the excessive demand regime is rooted in discrimination and conceals outdated prejudices that people with disabilities are a burden on Canadian society. Now, ironically, the source of these discriminatory laws, the UK, got rid of them, while we cling to a regime that fails to serve its stated purpose. In 2010, Canada celebrated our ratification of the UN Convention on the Rights of Persons with Disabilities, and the federal government has expressed its commitment to upholding and safeguarding the rights of persons with disabilities and enabling their full participation in society. Article 18 of the Convention specifically calls on states parties to recognize the rights of persons with disabilities to liberty and movement, to freedom to choose their residence, and to a nationality. The excessive demand regime clearly violates this convention. The UN has also repeatedly called upon countries to eliminate HIV-related restrictions on residents and described HIV-related discrimination in immigration as a violation of the right to equality before the law. By effectively preventing people living with HIV from becoming legal residents, the excessive demand regime also violates the rights of people living with HIV and other disabilities to education, employment, and health, as provided for in numerous international human rights laws which Canada has ratified. Several countries do not have any laws or policies that deny migration based on HIV status. The UK, for example, does not impose mandatory HIV testing for those entering the country as immigrants. Driven by increasing public pressure to reduce the number of migrants to the UK on the grounds that they were overburdening the social welfare infrastructure, the UK's all-party parliamentary group on AIDS nevertheless concluded that the UK government cannot look to exclude individuals on the basis of poor health in the UK while simultaneously working to provide access to health in developing countries. The same can be said of Canada, which has invested roughly $350 million between 2001 and 2011 on international projects with a focus on disability, and recently pledged over $800 million to the Global Fund to fight HIV, TB, and malaria. Yet the excessive demand regime would deny some of the very persons who we fund overseas from coming to Canada. Now, on a personal note, my brother and I now live in Canada, and my ill parents are left alone in Jamaica. Neither would qualify as Canadian permanent residents because of excessive demand. When one parent eventually dies, we will have the hard choice of what to do about the other. Our parents have been a great source of support to us. Now Canada's discriminatory immigration regime excludes them, and many others like them, from the care they need simply because they are deemed undesirable. This is a legacy that we should not continue to defend. Thank you.
So my name is Megan Johnston, and I'm a staff immigration lawyer at HALCO, the HIV and AIDS Legal Clinic Ontario. We serve people who are living with HIV in the province of Ontario. At HALCO, I witness my clients' pain and frustration caused by the discriminatory excessive demand regime on a daily basis. Even for people who are ultimately accepted, after all the paperwork, dealing with excessive demand is a terrible way for someone to start their new life in Canada, and the sense of exclusion that it creates stays with my clients for years afterwards. I want to illustrate this with some examples from my practice. So first, I routinely advise international students who have contracted HIV here in Canada during their studies. These students had planned to pursue their studies, gain work experience, then apply for permanent residence. Their futures are now turned upside down because their application to stay in Canada can now be refused because of excessive demand. This threat of refusal is particularly ironic since international students represent a group of immigrants that Canada states it most wants to attract. Second, at HALCO, we often represent clients in humanitarian and compassionate applications, H&Cs. Our clients' H&C applications take years longer to process than those of other applicants because they have to request waivers from medical inadmissibility due to their HIV before they are granted approval in principle. During this time, my clients remain in limbo, unsure of whether their application will be approved and they will get to stay in Canada. It's harder to successfully integrate when you spend years here not knowing if you'll be able to stay. One client's child aged out of the definition of dependent while her H&C was being processed. This meant the child could no longer be sponsored after my client got her permanent residence. Third, the excessive demand regime creates a climate of fear for people living with HIV. New clients regularly ask me on the phone or in person if their HIV status will be a problem for immigration, or even for citizenship, where it's completely irrelevant. Even people who are exempt from excessive demand still get the message that someone's HIV status can be, as so many of my clients put it, a problem for Canada. The discrimination inherent to the excessive demand regime isn't just in the refusals. It's in the way that the excessive demand regime forces people living with HIV and people with other disabilities into a different process, with more hoops and longer wait times because of their disability. That is discriminatory. Excessive demand is still discriminatory even if it focuses on the cost of health or social services and not the medical condition itself. This is a false distinction. It doesn't make a difference to my clients to know that they're not being refused because of their HIV status, but because of the cost of their life-saving HIV medications. They're still being refused. The department justifies excessive demand on the grounds of cost savings. But there are many costs associated with immigration, such as settlement services, language classes, and the cost of educating newcomer children. These costs, however, are not considered in the immigration application process. By only considering the cost of health and social services, and by using these costs as grounds for exclusion, the excessive demand regime relies on outdated and discriminatory stereotypes that people with disabilities are a burden, and it erases the important contributions that people living with HIV and other disabilities make to Canadian society every day. We urge this committee to show leadership and recommend removing excessive demand in admissibility by repealing Section 38C of the ARPA. Thank you.
Thank you very much. And Ms. Schweitzer and Ms. Benitez, welcome as well.
Good evening. Thank you for inviting me to share my story. My name is Mercedes Benitez, and I am a mother and a caregiver. I came to Canada in March 2008 under the Live-In Caregiver Program. My husband Romeo and sons Harold and Bill are in the Philippines. When I first came to Canada, Harold was 9 and Bill was 14 years old. I applied for permanent residence in 2010 after working for 2 years. In my application, I included my son and my husband. While I was working in Canada, I missed Bill's high school graduation. Because of my husband and I agreed that I should focus on completing the requirements of Live-In Caregiver Program. Even though it was very hard for me not being there to celebrate my son's graduation, to miss my boys' birthdays, and all our Christmases together, we could bear it because we knew that eventually we would be reunited. You cannot imagine the pain of a mother knowing that your sons are growing up without you. In November 2015, after waiting 5 years, I received a letter from immigration saying that we might be refused because of Harold's disability. Harold has intellectual disability. I was devastated. It hurts me to feel that the Canada thought we were not good enough. The month of uncertainty since we received the letter has been some of the hardest months of my life. I had chest pains. At times I thought I was having a heart attack from the stress. There were so many sleepless nights worrying that any day I could be refused and sent back home after working hard for so many years. I was afraid. Who would provide for my family? Sometimes it was too much to bear, and I thought of giving up. But my family relies on me. For support, I am the sole breadwinner. I needed to be strong. In Canada, it is said that everyone has equal rights, but the decision to find me and my family inadmissible based on my son's disability made me question this. I was eventually able to get legal assistance, and just 2 weeks ago, I was told we would be approved for permanent residence under humanitarian and compassionate grounds. I couldn't believe it. I feel like I won a lottery. I am so grateful, but I wonder what about others who are also in the same situation that I was in. I'm not sure how many of you are parents, but put yourself in the shoes of a mother who is being told that she cannot stay in Canada because her child has a disability. Excessive demand should be eliminated because there should not be any more mothers to cry every night or children who are being discriminated being on their disability or health condition. We need change now. Thank you for listening.
So my name's Tony Schweitz. I'm one of the lawyers at the Parkdale Legal Clinic in Toronto, and we were able to work with Mercedes. She came to us almost sort of on the cusp of her and her family being ultimately refused. And we were able to work with her, and as you have heard, her case was ultimately successful, but on a discretionary basis, on humanitarian grounds. And what I think you have just heard is a first-hand account of what this section does to people. This was a family who, for at least 5 years, was living with the threat hanging over their heads that they're going to be refused because one of their family members was non-desirable. So what I think you need to take away from this, you've heard lots of lawyers and bureaucrats talk. Now you've heard about what this actually does to people, the amount of mental and psychological stress that it actually causes to people who are here or who are applying, who are going to contribute. And that's exactly what Mercedes did. She has worked for many years as a caregiver to an elderly man in Toronto. And we all know that as we are an aging population, there's an increasing need for people who are going to do this kind of work. That's exactly what Mercedes was doing. And yet at the end of that, we as a country were prepared to say, well, actually, you're not good enough. Thanks. Now it's time to go. Her case didn't turn out that way. But that's not an answer to the unfairness of the law, because it is simply not acceptable to say that we can fix a law that is arbitrary and unfair by saying that there can be discretionary decisions made in the appropriate case. Then you're in a position where you're saying that only those people who have the ability to mount a case, to build publicity, to get the media involved, are the ones who are going to benefit. And that's simply arbitrary and unfair. And I don't think any of you would agree that this is a country where we should say that that is okay. I want to make two other points. And basically, I just want to supplement what others have said. And I want to take issue with a couple of things that you have already been told by other people who have appeared before you. So you, some members of this committee had asked other officials who had appeared before you whether this law has in fact ever been found to be unconstitutional. Previous witnesses have left you with the impression that this law has been carefully considered and found to be constitutionally sound. And I think it's important that you understand that that's not really entirely true. There are cases, there are in fact two cases really where this issue came up, one of which the court didn't really address it. It was a case of the Federal Court of Appeal in 2002 because the way in which the case came before the court didn't allow them to look at the issue from the point of view of the applicant who was being discriminated against. It was in this context of a sponsorship appeal, and therefore it was the sponsor in Canada, and the court said, well, it's hard to see where the discrimination is against the sponsor. So that case certainly does not stand for the principle that this law is constitutionally sound or that or that the Federal Court of Appeal so found it. The other case in which this law was looked at was the Chester's decision, which I don't know if any of you are familiar with, but was a challenge to the excessive demand provision as it stood under the old Act. And it was brought in relation to a woman who was the spouse of a Canadian citizen who at that time was subject to the excessive demand provision. And the court ultimately found that it was not an issue of discrimination because it wasn't based on disability, it was based on cost. I think you have now heard from enough people that while the language of the provision is in terms of cost, the way in which it is applied and interpreted is solely on the basis of a person's disability.
I need you to wrap up.
The important thing to know about that is that that case was literally on the cusp of the law being amended. It was in relation to a spouse, and as you know, spouses are not subject any longer to the excessive demand provision. And so in that case, it clearly had an influence on the judge. By the time the decision came out, the law had changed. So you are in the position, I think, to understand that it is not at all clear that this law is constitutionally sound. And I'd certainly say that, and in a case that came before it that had the proper preparation put into it, I think that it would be found to be unconstitutional. The last
I do
thing-
need to end you there. You may get a question that you get to answer that in. And I'm going to be a little bit uncharacteristically firm in our timing so that we can get everybody to have a round in here. I'll begin with Ms. Zahid.
Thank you, Chair, and thanks to all the witnesses, and thank you, Ms. Benitez, for your heartbreaking testimony. My first question is to Ms. Schweitzer. As I understand, the medical inadmissibility rules do not apply to the convention refugees, protected persons, and in many cases, some members of the family class, such as spouses, partners, and direct dependents. This seems somewhat arbitrary to me. Does it make sense to you that these rules apply to some categories and not all of them?
No, it doesn't. If you look at the fact that the way in which the law functions, as you've heard now in a number of different circumstances, the law is discriminatory, and then it's not a matter of saying this person should be able to, or we shouldn't discriminate only against this person, because there are situations like Mercedes where the law does apply. And so if you recognize or if you accept that there is a problem with the law, then the issue is not who gets exempted.
My next question is to Mr. Batista. Could you provide insight on the cost of legal representation involved in making an appeal of a finding of inadmissibility and providing a detailed plan to mitigate those costs likely to be viewed favorably by the department? Also, the federal court has held that it is unreasonable to find an applicant medically inadmissible when they have submitted a detailed plan for the payment of costs. So does this create a two-tier system of entry where those with the financial resources who can afford to secure a legal advice and mitigate their medical cost stand a better chance of entry into Canada, and those who can't afford to pay for those legal costs don't get a chance to come to Canada?
I think it's a very good question, and as I said earlier, we actually benefit from this medical inadmissibility provision because people turn to us for advice and assistance, which we provide to them, and expertise. It's a very resource-intensive endeavor to provide adequate submissions and to go on that journey with the client to build a case that they are not medically inadmissible. And our fees are high. Most lawyers that practice in this area do have high fees because it is very resource intensive. And yes, there are clients who cannot afford our fees that probably cope with a refusal. So I have often reflected upon the fact that it does seem to be economically biased toward those who can afford the legal fees to fight the determinations.
Any ballpark number of the cost which actually comes out to be?
Yeah, I can say that our fees solely on medical inadmissibility are probably in the range of about $4,000 to $5,000. And that is without the expert opinions that we often have to seek from doctors, from specialists, from psychologists, specialists with autism. So the fees are very, very high. But most people are willing to pay them because at that stage of their immigration journey, they're very close to obtaining permanent residence. It's the last hurdle. So in some senses, they will give it everything that they can give it because they feel that they are that close if they have a shot at it.
In your opening remarks, you talked about the enforcement of the mitigation plans. So how enforceable is a promise to pay medical cost? So once someone is a permanent resident and they have the legal right to access the public healthcare system, other plans may change. Sometimes people move to a job where they have different health plans under the employers. So bearing an outright and obvious case of fraudulent misrepresentation, are these plans really enforceable?
There's no enforcement mechanism in place to follow through with these plans, and that's part of the injustice and the unfairness, is that clients do sink a lot of resources into building these plans only to become permanent residents and then they just, as I said before, they evaporate into thin air. And some of my clients have said to me, why was the government so concerned that I had to invest all of this money and work with you to build a plan, and then I'm a permanent resident and there's no follow-through at all? And I should also mention that in order for there to be follow-through, the government has to be prepared to sink significant resources into tracking these mitigation plans. The government would have to establish a mechanism for the provinces to report on individuals who create mitigation plans to track their health and social service spending in every province. So if they move, the government would basically have to speak with every province to kind of track what they've been doing. And I mean, that would raise huge privacy concerns, so it might be impractical as well as very, very costly. And then there's the whole enforcement mechanism that would need to follow. So we're talking about removal orders, appeals, challenges. So it would be an extremely, extremely expensive project for the government to come up with some kind of enforcement for these mitigation plans.
Like once a plan is submitted and a person gets, that is accepted by the visa officials and they get the right to come to Canada and they become PRs, like where does this plan go? Like,
I have no idea. Nowhere. Into my storage cabinet. There is no follow through at all.
Okay. If I can ask Ms. Johnston to answer the next question. As provinces and territories shoulder the cost of public health care, should they have the ability to overturn a finding of medical inadmissibility if they feel an individual or a family make a contribution to the community that outweighs the provincial costs?
Sure. I think that, as Mr. Waldman had mentioned in the previous panel, that there did used to be a mechanism that did allow the provinces some more power in this area. But I think, again, though, this points to the unfairness of the provision as a whole and also the unworkability of the system. I don't think that it makes sense, and I certainly would not advocate that this committee just tinkers with a system that if it's already been recognized that there's a problem, that this system is discriminatory, then allowing the provinces additional mechanisms to sort of circumvent this discrimination, I don't think that's a fair way to approach the issue. And with respect to the point that it's the provinces who shoulder the burden of healthcare costs, I just wanted to mention that we have some concerns with the cost savings estimates that have been provided. So me and my colleagues, we've reviewed the transcripts of the first day when the department bureaucrats were here. And
I'm afraid I'm going to have to cut you off there. If you'd like to submit something to us in writing, that would be very helpful, or someone may follow up in another question.
It's in our brief.
Thank you. Perfect. Ms. Rempel.
Mr. McGuire has some questions, I believe.
Thank you. Thank you. Continue.
So as you can imagine, as my organization has been working on this issue for quite some time, we're very keen to see any cost savings estimates that the department can provide. So we were very interested by this figure that was mentioned here, which was the $135 million over 5 years, which I guess people narrowed down to about $27 million a year. But if you look through the transcript, it would appear that cost savings estimate is coming from the procedural fairness letters themselves. So how the department is estimating their cost savings is they're taking the cost estimate that's given to an applicant in that procedural fairness letter, and they're using that to estimate how much of costs are actually saved. But the issue, though, of course, is that my colleagues here have spoken to the inaccuracies in the procedural fairness letters. So, for example, for a client who's living with HIV, they may have switched to a generic HIV medication, which is much, much cheaper than the medication that's set out in the procedural fairness letter. But also, for example, with my H&C clients, we request and often receive waivers of medical inadmissibility. So this cost estimate, from what we can tell from the transcripts, these cost estimates do not factor into any revisions to the cost estimates that applicants may submit and any cases where there's granted a waiver. So our concern, based on the information that the department has provided to these proceedings, is that there's a significant overestimation of the actual cost savings. Lastly, that those cost savings do not figure or do not take into account, rather, the cost of actually administering the excessive demand program. As my colleague Mr. Batista has pointed out, and as Mr. Waldman pointed out in the previous panel, there's an incredible amount of costs that go into administering this program. And again, from what we're seeing from this transcript, those costs are not taken into account either. Thank you.
Well, Mr. Batista, I think you hit a home run too when you were talking about the dollars that are involved, and they can't be based on cost alone. Can you just tell me whether you think if the medical accessibility or rejections for medical purposes was dropped, if there would be an increase or an influx of people wanting to come to Canada with disabilities?
No, I really don't think that there would. It's not my impression that there's a number of people who have health issues that are just waiting for Canada to drop its medical and admissibility provision so that they can enter. Most of my clients are actually quite shocked when I tell them on the telephone or by Skype that Canada does this. Their typical response to me is, I thought Canada was a fair country. I thought Canada wouldn't discriminate. They still pursue it because they're very interested in Canada, but I have nothing really to say to them when they do make those comments about I'm surprised that Canada would discriminate in this way.
Yeah, thanks. And to you, Ms. Bennett, I am very glad for your outcome of your situation, but the situation that I was talking about earlier in the previous panel was one of the same area. Not everybody's fortunate to be picked or chosen or whatever on compassionate and humanitarian grounds. That's why I raised the issue of humanitarian issues in the previous panel. And while I appreciate the fact that it's there, it's where I was going when I asked whether a province could have some say in the finality of this. I've got, never mind the province wanting to pay for this, I've got a community that would have paid for the extra costs of having that individual live in their community, because the parents would be making far more than what the costs would be just in the taxes they would have paid. So there was a net benefit to the community, but it can't be a net benefit if they're all rejected as a family. So, and of course, they weren't going to stay if the youngest person in the family was rejected. So, do you have any comments on that? Or maybe Ms. Schweitzer as well?
Well, you know, that's part of the problem with this, is that those cases that, you know, get a certain public profile, there is the ability for IRCC to resolve those cases on humanitarian grounds, but that simply can't be an acceptable answer to a problem with the law. The fact that it's entirely arbitrary as to whose case gets that kind of profile, who's able to get the kind of help to do that, we are not that country. And I would certainly hope that none of you would be prepared to say that that saves a law that's problematic.
Thank you. The arbitrary part was exactly what I was getting at, and it's too arbitrary in that regard for individuals that just can't afford it. And so that's
and for all the Mercedes and the outcomes on her cases, there are however many other cases of people who don't have yet, or maybe may never have a solution. And you've heard what the law does to people. You have to think about that in determining whether it is, you know, there is any way in which it can be said that continuing this situation is fair.
Thank you.
Ms. Kwan.
Thank you very much, Mr. Chair, and thank you to all of our witnesses. I want to first off say congratulations to you, Mercedes. Your story, I actually think because you had the courage to speak up and brought this to the public realm, that's why we're here today. And the fact that you won your case not less than 2 weeks ago, you still show up to make the pitch and to say why this law needs to change. I can't tell you how much that demonstrates the value in which you add, and people like you, to our society and to our country. That is what we're talking about. And I don't know how we measure that. Not in a dollar, not in a cent, but I'll tell you, that is worth its weight in gold in terms of what you stand for and the humanity that I think Mr. Ray talked about earlier, about who we are as Canadians. So thank you. Thank you for that. I want to talk about the international law issue and the fact that Canada, you know, we say we're back, and it's so good to say we're back. So let's measure up on this policy, on how we're back. So Canada has made commitments to equality and human rights of people with disabilities in our Canadian Charter of Rights. And we have done so provincially and federally with our human rights legislation. And we have also signed on to, as a signature to the UN Convention on the Rights of Persons with Disabilities. Yet we have this law, the Immigration and Refugee Protection Act, which states that an individual would be discriminated against based on their different abilities. And so to that end, for us to say we're back on this score, what does the government need to do? So I'm going to go down the line to everybody, if you can get your comment on the record for us by way of recommendations. And the short answer, because we have limited time. We'll start with Mr. Tomlinson.
Quite simply, we have to repeal the section. It is in complete violation of our international obligations, and any reasonable assessment would prove that. It is a violation, and what was ironic is when we ratified the UN Convention on the Rights of Persons with Disabilities, we did this at the start of the Vancouver Paralympic Games, when we welcomed the world of disabled individuals to Canada. So you could play here, you just couldn't stay here. That's what the message was sent.
Thank you. Ms. Johnston?
We also recommend a full repeal of the provision. The discrimination is not in keeping with the idea, as you phrased it, that Canada's back. We also think that the resources that could be poured into tinkering and making the system more accurate and getting more information, it's not worth it. So we oppose all discrimination and we recommend full repeal.
Thank you.
As I've already said, I think that the law discriminates when it acts to refuse somebody with a disability from being eligible to immigrate to Canada. I think there's a serious problem with discretionary waivers or exceptions to overcome that problem. And I also think, as I think Mr. Batista made reference to the Global News piece about where the numbers come from. And I just wanted to add one quick thing to that, and that was that when you last time Mr. McKinnon testified before you and talked about how the global piece was wrong because they weren't looking at the right, they were taking into account too many things, and that, in his words, we consider only a narrow basket of social services. And he said we don't consider social assistance, we don't consider social housing. Well, that's in fact not entirely the case. There have been cases that we have seen where they have looked at housing and they've looked at social assistance. So I think what that means, or the takeaway from that, is that those the way they came up with those numbers is arbitrary, and that perhaps Mr. McKinnon himself doesn't entirely know all the decisions that are being made by officials underneath him because he didn't seem to be aware of that. And I think that arbitrariness is simply unacceptable.
Thank you. And it goes to highlight the point that the issue of assessment is entirely flawed, and there's just no way to actually really fix the issue before us. A quick answer from you, Mercedes, please.
Yes, I really think even though my case is already resolved, I really think that it should be repealed, the excessive demands. It's really it's like yesterday, I still feel the pain when they say no, you are good to work, but you are not good to stay because of your son. And this morning, I had a chance with a press conference, and there's still cases there, like my Filipino colleague, like Josery Danieles, who got a young daughter, with the same situation as me, and I cried with her. She is so devastated, and I still feel the pain, like in my heart. Like there was a time that I really cannot even write the word Canada in my letter. And I'm thinking, someday I cannot write anymore Canada as my address. I'm living here for almost a decade, and someday in my mind they will just send me home because of my son's condition. And I'm here to stand for them, and I really still fresh. It's like in my heart is still fresh. I can still feel their feeling right now. And there's a lot there, like from my village, from my country, who are not only in my country, all over maybe another countries that really impacted by this kind of discrimination of excessive demands. Thank you.
I would say, with the exception of this provision, every other aspect of Canadian society, business, government, our education system, are encouraged to see people with health issues and disabilities for what they can contribute, not that they are a burden. So this law is completely out of step with Canadian society. It's a relic of our past, and I think it should be repealed.
Thank you. Ms. Smith?
I just think if we look at the practicalities of how many people the system is actually catching, so if it's 900 applicants per year, so 0.2% of all the people that are applying to Canada, we've heard about all the problems with the system, the amount of resources the government is going to have to sink into making the system workable. If the goal is cost savings for the government, it just doesn't make sense to keep this program in place.
Thank you. We need to end there. Mr. Whalen, to bring us home.
I believe that I'm sharing my time with Mr. Andia Sangri, and he will start.
We'll really do it.
I have a very brief comment, and this is to Ms. Schweitzer. Welcome. Both my wife and I are Parkdale alumni, and really thank you for your advocacy over the last 4 decades, I think. With respect to your comments relating to the legality of this provision, it still hasn't gone up to the Supreme Court in terms of adjudication, right? If I recall.
It hasn't. Whether or not this provision is constitutionally sound has not gone before the Supreme Court of Canada. The issue that went before the Supreme Court of Canada, which was in the Hillowitz decision, had to do with whether or not they were people were having what could be considered individualized assessments, and it led to this process that both Ms. Smith and Mr. Batista talked about the mitigation plans. The court did not directly address the issue of the constitutionality.
Right, and with respect to the mitigation plan, what other options are available other than repealing this particular provision? How do you mitigate? Basically, how do you ensure that that those cases are adjudicated in a manner that is that takes into account kind of the real reality that currently exists with excessive demand? How do you do that without repealing that particular provision?
Well, I don't know how to. I don't have any suggestions, actually. I think the law discriminates. And the justification, the numbers that have been provided are arbitrary and inaccurate, and it appears even sort of senior officials are not aware of some of the things that are being done by decision makers. That's a situation that is unacceptable. So I don't know what else I could say to that. I can say that the system as it stands is unacceptable, and it can't and it shouldn't continue.
Thank you. And Mr. Whalen?
Thank you very much. Thank you all for coming tonight. I'm not sure if you've been listening to some of the previous testimony that we've had, but there's been a lot of misgivings from all of us here about excessive demand and why we are quantifying individuals in this way. We don't do it in any other aspect of our lives. But I just wanted to be clear with each of you exactly what the ask is or what the recommendation is regarding repeal. And to confirm that you're not asking us to repeal sections 38(1)A and B, which regard to dangers to public health and public safety. It's just section 38 sub 1C, which is with respect to excessive demand. Or if you are asking for repeal of all of it, just to provide some explanation. So maybe we can just run down the table, starting with Mr. Tomlinson.
Just 38(1)C is what we wish repealed. Yes. Excessive.
I don't know. I may be speaking out of turn. I think he probably can speak for all of us. I don't know.
Okay. Okay. That's wonderful. And on previous meetings, we talked about the prices, and whatever the prices are, just when you take the grand scheme of all of the costs associated with Canadian health care into account, it's a giant insurance scheme, and some people are healthy and some are not, and we try to get by as best we can. And we have immigrants that are coming into our country, and some are healthy and some are not. They're human beings. And so I'm not sure what else to say other than that thank you very much for your testimony today, and that's the end of my question.
All right. Did you want to ask another question?
If I may, I'm sorry, Mr. Chair. If I may just put on the record that from my office, I've received over 1,000 letters or emails, if you will, regarding this issue, calling for the government to repeal the excessive demand provision. So I want to get this on record, and I will be happy to give a sample of that email to the clerk so that we can register it. I suppose I can print 1,000 copies for you, but maybe I'll just
sooner not.
do it that way. So I want that on a record, if I may. Thank you.
And if I may, Chair, I'd like to also on the record say that Canada is behind nearly a dozen countries that have no excessive demand provision. Countries, as was repeatedly said, we are competing with for talent. Most of Scandinavia, even our friends to the south, the UK, Ireland, many countries have no such provision, and they seem to be getting on quite fine.
All right. We'll get information on that, I'm sure. Look at this. We're going to end this part of the meeting, take a brief moment to usher our witnesses out. It's not an in-camera meeting, but we have some business we need to do following this. And then so I'd like to resume as quickly as possible once we've done that, okay? Thank you, witnesses. They don't jump with the gavel.
They don't. You're not commanding enough.
We're going to call the meeting back to order.
Larry, Yancey, meeting started. Yancey.
He's on Manitoba time. All right. I want to get us going back to, just before we get into the business portion of the meeting, there had been a request from Ms. Kwan for a baseline study that was done in 2004, upon which the rates were set and then increased through inflation and experience over the time. She has requested a copy of that, which I think is would be very good for a committee. I think it would be good for the committee to have it before the minister is here. However, it is only available in English, and it is about 50 pages. So I'm going to seek unanimous consent that we could have it to the committee. However, knowing that we would have French translation immediately following as soon as it's available, just to have that available for people to understand. So I am going to seek unanimous consent on that. All right. We recognize this is an exception, that all the documents will be bilingual, and it will come hopefully as quickly as possible, but we're doing a compressed study, so I think it is an exception. Mr. Hernandez.
With real exception that this is the one and only
exception
time,
is noted by that. We're going to continue our discussion. At the end of the last meeting, Ms. Rempel had presented a motion, and I think it's probably, I can't tell from the Blues who actually had the floor at the end of the meeting, so I'm going to turn it to Ms. Rempel.
Point of order, Mr. Chair. Is this component of the meeting being televised?
Yes, we're continuing.
My understanding is that right now it's not being televised on Parleview.
We did.
It said that the meeting was suspended.
We're after 8:30.
It was supposed to be.
It should be.
We didn't. We're not in camera. We're continuing as normal, but we also have people who may need to leave. I don't know. We're on. Okay, so I'm going to turn it over to Ms. Rempel, who has the floor and the camera. If you would restate your motion, reread it so that we can begin it again, and then we can continue debate on that motion.
Yes, so I move that notwithstanding the motion adopted by the committee on October 16th, 2017, the committee hold an additional meeting prior to December 20th, 2017 on the resettlement issues related to Yazidi women and girls, and that the committee report its finding to the House, and that the government table a response. So maybe I'll for the committee's benefit, I'll give a little bit of a background on my week last week during our constituency break. I had the opportunity to meet and call with several of the community groups that are providing resettlement services for the Yazidi community across the country who watched what happened at committee last week. To my colleagues opposite, the Liberal government has majority government right now, which means you have a majority on this committee, which means that the Liberals, should we adopt a report, have the ability to basically word the report as they see fit. Opposition members have a dissenting report that we can put on the end, but the requirement, the thing is with a report is that the government is required to respond. So I don't understand why the committee members would do anything other than have a report attached to this committee, to the findings of this committee, outside of the fact that they have been directed from the center that they don't want the government to respond to this. Here's what happened last week. I sat in the living room of a Yazidi family, and I had to listen to stories about how they have family members in other parts of the country that have been redirected, and they do not have adequate, they're isolated, they're struggling, we don't have enough translation services for people. You know, there was never an intent of this committee, and I certainly hope not of the government, to bring these people here who have suffered so much and just to leave them to their own devices when, frankly, their lives are still at risk. And frankly, I want to take issue with something that was said at the last meeting, that, you know, moving this motion was conservative. I can't remember the word that was used, histrionics or hyperbole or theatrics. Yes, I get worked up on this issue, but every Canadian should get worked up on this issue. And the member who said that, I would like to ask for an apology on it. I do not understand why every single time this issue comes up before this committee, we can't just do something that resembles work. My understanding is that somebody from across the table is going to move a motion that this is going to be a letter to the minister, which the Liberal members will do anyways, and it removes the responsibility of the government to respond to the work of this committee. If the government members want to respond to the centre, if they want to take direction from the centre, rather than people that are sitting at the end of the table, that is fine. That's your prerogative. You can write the recommendations in that report how you see fit. I want the government to have to respond, because if we don't get this right, we are failing the world's most vulnerable. I am so sick of sitting in the living rooms of these people, of listening to these women, and us failing to act on their behalf. I don't want to have to come to our chair and to each and every one of you every 3 months asking for another report on this because we are not making ends meet. I don't want to have to keep asking our chair in the House of Commons what we're doing. I don't want to have to keep listening to department officials saying that only 5 women have had access to care. I just want it done. And I don't understand why this is so hard for this government that makes their brand welcome to Canada, something that's compassionate. So if somebody across the way is going to entertain amending this motion, I don't accept it. I'm just going to preempt you right now. We need to have a report out of this study. We need to have some concrete recommendations on how the government is going to go forward. The Liberals in this committee can do what they see fit. Every single person that I met with and called this week do not understand why there is a disconnect between the message that the Liberal puts forward with the Syrian Refugee Initiative and this particular cohort of people. I don't understand it either. So I ask each and every one of you from the bottom of my heart, from a place of genuine concern for women whose lives are at risk, to just issue a report. Your minister can put forward whatever he responds, but you cannot have good government unless you have good opposition. And I am so tired of keeping my staff involved in this. I'm just so tired of spending so much time on something that your government's supposed to be good at. So I look at you as members who are not part of the government. Your job is to hold the government to account too, even if it's the same party. So if you're going to amend this motion, no, I don't accept it. If you want to put forward a letter to the minister, that's cowardice. If we're going to do this, we should do it right. And there's absolutely no reason outside of cowardice and bowing to the center and abandoning these women that we would not put the findings of this committee study into a report. I'll rest my case.
Ms. Zahid.
Thank you, Chair. I would like to move an amendment to Ms. Rempel's motion. Amend by deleting everything after women and girls and replace with the following. And that the committee write a letter to the Minister of Immigration, Refugees and Citizenship Canada, reporting on the testimony it has heard during this briefing.
So we debate the amendment. Ms. Kwan.
Thank you very much, Mr. Chair.
Could I just clarify one thing before you say, when you say a letter, are you referring to it as an open letter or a confidential letter?
Open letter.
Okay, thank you. I just wanted to clear because there are 2 kinds of letters that can be sent. Thank you.
Thank you very much, Mr. Chair. Well, I would not support the amendment, Mr. Chair. I think that the reasons are quite obvious, really, and that is for us to do our work. We had compelling information that came forward from the officials and from the witnesses that came before us. And to write a letter, what is the difference, right? Some people will say, well, what is the difference between a letter versus a report? Well, there's a significant difference. A letter is simply to say, here's what we heard. A report will speak to recommendations, and the government will have to respond to those recommendations per the rules as they apply to committee. I think that there's value to that. I think there's value to that for both the opposition, but for the government members too. But more importantly, I think there's a lot of value to that, to the people who came before us. I can't get out of my mind the victims, if you will, the survivors, and particularly Nadia, who spoke with us in her first meeting in the summer. Seems so long ago now, but really wasn't that long ago. And I remember meeting her at my office, and how, just looking at her, I saw how her trauma was haunting her still. But in spite of that, she found the courage to come before us, to advocate, and to do this work, and to continue to this work. And the work is not done. The job is not done. We've only just begun this work. And in that process, when we heard from the witnesses in the summer, I had always envisioned that the first wave and the first phase of this work was to do this immediate 1,000 plus people in terms of coming forward, and that there were steps to follow. We all heard that at the committee.
Point of order, Mr. Chair. I have a staff member who very loudly was interrupting my colleague and disrespecting her by saying, quote, "Just let her talk it out. Just let her talk it out." This is disgusting. You should be ashamed of yourselves. Point of order on decorum.
I would say it's not a point of order, but the member please continue.
Thank you, Mr. Chair. Well, I won't bore the members, I have to say.
Don't give me a look like that. Don't give me a look like that.
Order, please.
No, you can't. You don't have the right to look at me with a sneer when we're dealing with something like this.
May I have order? Ms. Kwan has the floor.
Thank you, Mr. Chair. I would just simply finish saying that it was always my hope, and I thought was the committee's vision as well, that we would do this work in the summer as phase one, and which the government did act on, was to bring the 1,200 Yazidis over by the end of the year. But we always knew that that work was not complete. We always knew, at least in my heart, I knew that that work was not complete, that we needed to continue. From the witnesses in the summer that came before us, that's what they also said as well. And so that's exactly what the witnesses in this round, what they said to us in terms of the work that needs to continue. So I really don't understand why there is harm in for this committee to do our work independently. Mr. Chair, you are a new chair to this committee, and you have said to me, and I don't think you mind me saying this publicly, that this committee works independent of government, that it works independent of the minister, that we have our own minds, that we have our own capacity to do our work. And the chair before you, Mr. Oliphant, also reiterated the same thing. And he said to us that the work that we do here could be some of the most important work that we will do as members of parliament. We have a chance to make a difference in putting forward this report. We're talking about saving lives, lives of people, of women, of victims who are being raped, who are being killed, who are coming out to say and pleading for help. There is a genocide against this community. We owe them that much to say that this work will continue. We owe them that much to do our work as committee members, to put a full report to the minister and have the minister respond to us accordingly. That is accountability, that's transparency. And if we do that, we should all be very proud of what we're doing here, even when we disagree, Mr. Chair. So I hope the members will retract the amendment. Let's get on with it. Let's get on with it and do something that's kind of really cool, I think we can do it.
I've got Ms. Rempel and then Mr. McGuire.
So I'd like to propose a sub-amendment to my colleague's amendment, that following on to her amendment, it would read, and that the content of the letter be developed in a televised meeting, and that the minister appear before committee to respond to the letter prior to February 28th, 2018. I would like my colleagues to have to go on the record to defend the fact that they are not requiring the government to provide a response. So if they don't want a report because the center or their parliamentary secretary or the staffer in the green shirt that just told my colleague to talk it out should be embarrassed. You know, at the next time, honestly, Mr. Chair, I would invite that staff member to come and meet with me when I have to meet with these Yazidi women. I would love that staff member to come and watch and listen to those women, and we'll see who's talking it out afterwards. Shame on you.
Point of order, Mr. Chair. I think she's being a bully and harassing staff members, and I think she should apologize for that.
And Mr. Chair, I would like my colleague who said I was being theatrical in the last meeting to apologize to me. I would like my colleague opposite who gave me a steering look to apologize. This is serious, and I make no apologize for being serious on this issue.
Order. Ms. Rempel has the floor.
Thank you. I think that the minister should have to, if we are not going to issue a report on this, I do not understand why the minister should not have to come in front of committee to answer to this. And the other thing is, I've had experience drafting letters in this committee before. It has not been a pleasant experience. And I would like, if the Liberals are going to draft using their majority, a sunshine and roses letter to the minister that he's not required to respond to, I would like that to be done in public so that the witnesses that we've had before this committee can see deliberations, and I would like the minister to come and to respond to this. I am furious. You know, I don't understand why we can't act on this. I do not understand why we are not requiring the government to respond to this. Honestly. There are real challenges. We're doing something new. The government, to their credit, we're doing something new. But the reality is that this group of people have different needs than other groups of refugees that we have brought in, and we are not capable right now of meeting their needs. That is the role of this committee. We have had recommendations. The government might not agree with it. The government side might not agree with it. That is fine. But we need to do our work as parliamentarians and say the system that we have, the siloed system of standardized support for GARs, is not meeting the needs of this group of people, and their lives are at risk. I do not want to have to come back here because one of these women have taken their lives, and that is what we're talking about here. I don't want to have to do that. So I do not understand why we can't have a report, and if we cannot have a report, I want the content of this letter deliberated in public, and I want the minister in front of committee to respond to it by the end of February.
Mr. McGuire.
Well, thank you, Mr. Chair. I want to just, first of all, now that there's another motion here as well, speak to that. I guess I feel strongly that a letter is not required here. We should I see nothing wrong with having a report, because when we spoke to these witnesses, we asked them specifically in the last time we met whether or not this met the criteria to be a recommendation, and this topic was a recommendation, and we did that about 5 or 6 times, and I believe all members on the committee, all 3 major parties here, did that. There were recommendations that came forward. Recommendations usually go in a report; they don't go in a letter. The word recommendations was used. I jotted a number of the things down in my own notes. I remember that witnesses had said at that time. And, in the scheme of collaboration on this whole thing, I was of the understanding perhaps that when we're having the 4 meetings this week on medical inadmissibility, that we would possibly be able to have another meeting to look at hearing from directly the witnesses of Yazidi women that have been injured or persecuted, I would say, by the situation that they've been put through, and that we would be able to hear, and Canadians would get a better feel for exactly the need for the changes that may be required here. They're not that outstanding given the number of people involved, as we've seen in the admissibility situation this evening as well. But I believe strongly that there is a need to have this recorded as a report as opposed to just an open letter, just from the accountability of the whole process and the responsibility that we have as Canadians and as members of the backbench and the opposition to make sure that the recommendations are going forward. Government doesn't have to act on them. I believe that they probably would, in some cases, make some adjustments in the whole process. I think it's very reasonable to ask for that letter to be dealt with. We've already seen, I believe, some of what would be public in it, but we could put those forward if we were to secure another meeting with witnesses to have the opportunity to strengthen what would go into the recommendations. And it gives us an opportunity then to be able to respond to it. I think that the motion put forward by my colleague, Ms. Rempel, just now is sort of the best that you could get out of the recommendation or the motion that the government side has brought forward, the backbench committee from the Liberal government, and regarding to wanting to have a letter, particularly when it's so transparent that it was apparent that it was already coming. I just can't believe myself that the recommendations couldn't be accepted, that basically everyone in this room knows are already out there. They're on the table already. They were the last time we met 2 weeks ago. And I believe that 2 weeks or 10, 12 days ago, at least anyway. And I believe that we could certainly live with the opportunity of developing those recommendations in the committee, and then having them having the minister come and appear before us to deal with such an important issue. I mean, the government has already the ones that have said that they would bring in 1,200 Yazidi women and move this forward, move it as quickly as we can, to be able to accomplish the goal that the government has set for themselves. And I think the witnesses all know the difference between a report and a recommendation as well, or a report and a letter, and I think they would feel much more inclusive in the whole process if the discussions that we were taking place, if they knew that there was going to be a report. They've witnessed what happened 12 days ago, 11 days ago, whatever it was, and the last meeting that we had, and I believe that this would be very valuable for the government to have in their hands as a report, and so I'll leave it at that for now and see if there's any other concerns. But I would certainly recommend that we drop both motions, both amendments, and go back to the original motion.
Okay, I have Ms. Kwan and Ms. Rempel on the list. Just looking around. Okay, Ms. Kwan.
Thank you very much, Mr. Chair. Well, I guess speaking to the sub-amendment, so that would be the amendment that Ms. Rempel had just moved. I will simply say that my preferred option is to do a report. I think that's the proper thing to do. But if that's not to be, I would support this sub-amendment for the purpose of accountability. I think that above all else, we need to be accountable to the people that elected us here, accountable to the people that got us around this table to be committee members, accountable to the witnesses who took their time out to present to us, and accountable to the international community as well. When we say that, Canada wants to be recognized for our humanitarianism and compassion, we need to demonstrate that. So I think in the minimum, we need to ensure that there's absolute transparency with respect to this process and with respect to an issue such as genocide. Mr. Chair.
Ms. Rempel.
So, Mr. Chair, the last time that this committee wrote a letter, it followed the hearings that we had in the summer of 2016. There was, at that time, I believe, a desire to do more. But what ended up happening was this committee wrote a letter to the minister. It was a self-congratulatory, do-nothing letter. And, I'm looking at a CBC article here right now. This was July 22nd, 2016, where this letter came out with no requirement for a response, where one of my colleagues opposite said, well, this is the best that can be done right now. So then it took another 4 months of, browbeating to come up with some sort of a motion or a solution, and then another year. This is another year. We're now a year and a half into this. So I don't find it acceptable that the government feels that their response to this situation is a self-congratulatory letter that requires no government response. This is not what the resettlement services agencies need. This is not what these women need. They need help now. So I just, you know, Mr. Chair, you have done good work on chairing other committees. You've been very passionate on some of these issues. You know, to prove my colleague, Mr. Sarai, wrong in saying that this is somehow conservative theatrics, I would implore you and I would ask you to talk to your colleagues to suspend the meeting briefly. Hopefully they can caucus. There is no reason why there cannot be a report. The Liberals have a majority on this committee and they can write whatever they want. I want the government to be required to respond to the testimony that was put forward at this committee. That is what members of Parliament do. A self-congratulatory letter it disrespects the community effort that is being put forward to help these people, and it disrespects the government actually doing something on this particular file. Canada should be developing best practice on this, not trying to sweep this problem under the rug. We had this committee meeting, hopefully to do something that resembled work and got some help out. A self-congratulatory letter that is developed in secret that requires no government response does not do that. And I will be before this committee every single time we hear an issue, every single time something happens in the community, reminding the members of the fact that we wasted time and we wasted the resources of the government in closing our response to this with a nice, flowery letter from Liberal members who are listening to staffers and the centre to their minister. So if this is what the members want to do, if they just want to push this away and they just want to I'm sure they've got something drafted already. I ask you as the chair to perhaps talk to some of the other members on this team and just, they can write whatever they want in this report. They have the majority on this committee. It can be there. There is no reason why we would not have a report or not have the minister come to committee outside of the government wanting to hide this or sweep this under the rug. So yeah, I'm going to get theatrical about this, Randeep, because I don't get this. I don't get why this is the fourth time we've had to go through this conversation by now. I don't get why you've given me half an hour on camera to get angry at you when you could have just voted to have a report. The government will respond. We'll make sure that the minister gets here somehow. Why don't you just let the government respond in a written report? This is insanity and it's lunacy and it's not what we should be doing with a parliamentary committee. So I ask you that, Mr. Chair. If you could even take 5 minutes, maybe people across the aisle there will want to caucus for a minute and talk about something that is more reasonable than what's on the table right now.
If you would like to request that we take suspend for a few minutes so anyone could caucus who would like to caucus, that would be appropriate.
I would like to request that with the caveat that I hope and I would love for my colleagues to caucus with you. I would love them to caucus without the talk it out guy standing in the middle of it. I would just really, really love for this report to be issued. It doesn't have to be long. It'll get tabled before committee. The government doesn't have to respond until after the Christmas break. I just want motion on this.
Whenever I have a request to suspend for a few minutes, I accept it. And so we're going to suspend for 5 minutes. And anybody can caucus with anybody they would like to caucus with. We'll take 5 minutes. Thank you.
I would read the motion as that notwithstanding the motion adopted by the committee on October 16, 2017, the committee hold additional 2 meetings prior to December 20th, 2017 on the resettlement issue related to Yazidi women and girls, and that the committee report its finding to the House and that the government table a response.
Would you, do we need to debate, or would you like to vote on that? So there's an amendment to move to 2 extra meetings instead of 1, and that we have a report, and that there is a response from the government. I've got Ms. Kwan and then Ms. Rempel.
Thank you, Mr. Chair. Not on a point of debate, but rather on a point of clarification. So if this motion passes, and so we would have 2 additional meetings, just like to get clarification in terms of witnesses then, how would we proceed, and names and timelines.
I would send out a note through the clerk to ask for additional witnesses, and if we don't have, maybe up to 2 meetings, that maybe just be easy, up to 2 additional meetings, because I wanted to make sure everyone got a chance to put in all their witnesses, and then if we needed 2 meetings, we'd have 2 meetings. If there's only enough for 1 meeting, we'd only have 1 more meeting, and then do the report after that. We have time to get this done before the House rises in December. We won't get the report fully written, I know, and translate all that stuff, but we're going to get the 2 meetings, and if we need them, we may only need 1. But it'll depend on how many witnesses you submit.
Okay. I'm sorry, did I hear you correctly to say that we will have a chance to table the report before? No. Okay, thank you.
The analyst advises it just, even if we don't have any more meetings, we're not going to get that done.
Okay, I just want to clarify.
In full disclosure, the reality is I want this to be done well, and I want to make sure we have enough time. If we don't need 2 meetings, we'll only take 1. But I have a feeling that there's a bunch of questions. I also asked the analysts to prepare a summary of evidence, so that we'll have the summary of evidence that you can all look at to decide what you would like to have in terms of other witnesses.
It will be ready for Thursday distribution.
It'll be ready for Thursday distribution, summary of evidence, and to be fair, just so that you can really do the work of the committee. You're okay?
I would just like to thank my colleagues for this consideration.
All right. All in favor of the motion, of the amendment, sorry, the amendment? Any opposed? The amendment is carried. Are you ready to vote on the motion? As amended. All in favor? Any opposed? That's carried. And Ms. Kwan.
Thank you, Mr. Chair. I'd like to just put a motion on notice, if I may, and the motion would read as follows: that pursuant to Standing Order 108, Sub 2, the committee undertake a study of the increasing incidence of forced internally displacement globally and how Canada can best respond to the humanitarian crisis involving forced internally displacement, that this study should be comprised of no fewer than 3 meetings, that the Minister of Immigration, Refugees and Citizenship be in attendance for at least 1 meeting, and that the department officials from Global Affairs Canada and Immigration, Refugees and Citizenship Canada be in attendance for at least 1 meeting, and that the study be concluded, and that the committee reports its finding to the House, and that pursuant to Standing Order 109, the government table a comprehensive response thereto.
Thank you. That's been received. Any other business to come to the committee? I will see you in about 10 hours. Meeting's adjourned.